When we talk about estate planning, particularly if we're looking towards long-term care planning, in other words, how do I pay for long-term care without losing everything? How do I get VA pension or aid in attendance? How do I get Medicaid? Part of that analysis and part of the solution may involve transferring assets out of my name into somebody else's name or into a trust or doing something with those assets. And so often a question is asked, well, is it the cheapest thing to do just to give it to my kids? Give my house to my kids, give my stocks to my kids, give investments to my kids, just put my kids on my bank accounts? Isn't that the cheapest way rather than paying for a trust or doing something that sounds more complicated? And the simple answer is yes. That generally is the cheapest, at least immediately. It's the cheapest way to go. So you have a $500,000 house, you sign that over to your kid, you can get a real estate lawyer to do that for, I don't know, a couple $100, pretty cheap. You go down to the bank, put your kid on the CD, the bank account, you go to Merrill Lynch, wherever you have your investments, do the same thing. Very cheap, and it can even be free. But is it the best solution, and ultimately is it the cheapest solution? So have you think about a couple things. One is taxes, one is creditors, and one is predators. So let's take those in order. Taxes. Let's say you bought your house for $100,000 and now it's worth, we'll make it not $500,000, but $300,000. So you give that to your kids, and that's a gift. Then when you pass away, they don't get what's called a step up in basis. And I'm not trying to make this overly complicated, but your tax basis is what you paid. You paid $100,000. If you die, then and the property is inherited by your kids and it's worth $300,000, now their basis is $300,000. So they go out and sell it the next day, they don't have any taxes. But if you just give it to them, they take it at that $100,000. So then they sell it for $300,000. Well, now they may be paying taxes on $200,000. So that very cheap solution may not be so cheap after all. Well, what about creditors? So you give your house, you give your stock account, your bank account to your kids. And a year later, they're in the middle of a lawsuit. They're in the middle of a fight with their bank on maybe a foreclosure or a business deal has gone bad, and now creditors are coming after them. Well, that house is now their asset. That bank account, that investment account is their asset. And that creditor can reach in and grab that. You say, no, but I gave that to them just to keep it safe so that if I ever needed to go in a nursing home, I wouldn't lose everything. Well, I understand that was the purpose. But giving it away directly to your children is almost always the wrong decision. Because the creditor doesn't care what you had in your mind. You have to truly give up control, give up ownership of that asset. And when you do that, that means your kid owns it now. Well, what about predators? We talk about taxes, creditors. What do I mean by predators? Well, what if you give your house to your son and 2 years later his wife says, I want a divorce? Well, that's his house now. She's going to get part of that, maybe most of it, depending on the circumstances. You say, no, but I gave it to him to protect it from the nursing home. She doesn't care. Yeah, you might have an ex-daughter-in-law who says, well, I don't want to do that. But are you going to rely on that? If she's divorcing your son, are you going to rely on the fact she's going to go, you know what, that $300,000, $400,000, $500,000 house, forget it. I don't want any part of it. That would be surprising to me. Well, let's say they don't get divorced. Let's say that he gets sued for a car wreck. Maybe it's his fault. Maybe it's not his fault, but he still gets sued for it. And he's only got $100,000 in insurance and somebody's claiming $1 million of injuries. Well, they're going to reach out and grab that house if they get a judgment. And again, they don't care that, well, really that was mom's house, dad's house, they just gave it to me. They're not going to care about that. You think their lawyer's going to care about that? No, their lawyer won't care about it. Well, what about in a business deal, of a business partnership? That blows up, and now they're suing each other. Any of these types of predators, it could be lawsuits, divorce, we talked about with creditors also bankruptcy. Here's the rule of asset protection, because that's a term that's used. And you may have heard of it. People talk about, I got to protect my assets. If I have the ability, so John Watts has the ability to reach in and grab an asset, my house, my investments, whatever it may be, then my creditors and predators have the ability to reach in and grab that also. So if you give it to your child where they now own it, that means their creditors and predators can get to it, and you may also be costing them a fortune in taxes down the road. So I hope this has been helpful to you. Just want to give you kind of a flavor or an idea of what some of the problems are with giving it away to your children. Again, is it cheap? Oh yeah, it's incredibly cheap. A lot of times there's zero cost to it. But down the road, it may cost everything to do it that way. And there are just much better options. And some are very expensive and some are not very expensive to be able to protect those assets, but still get it to your children at the right time where it's protected from their creditors and predators. So if you have questions about this or other estate planning or elder law or asset protection questions, give us a call, 205-879-2447. And again, my name is John Watts, or you can contact us through alabamaelderlawyer.com. And we have several offices around, and we really represent people all over the state. So wherever you are, if we can help you in Alabama, feel free to give us a call or contact us through our website. Thank you.